Well, welcome everybody to our extended learning call, the first one of 2026. I hope that you all have had a happy holiday season, and it's difficult to go back to work after the holidays, isn't it? I'm kind of dragging, but without further ado, we're happy to provide some information on guardianships and some alternatives to guardianships. And Vicky, our staff in Bismarck, is going to walk us through that, and she's done a phenomenal job, as she always does. Many of you know Vicky from working with her, but she's always full of a lot of great information. So, Vicky, I'm going to let you take it away, and I'll let people in as they join.
Okay. Whoops. Can you see my, oh, I can't see my own screen. Hang on. Can you guys see it?
I can see it, but it's not in full view mode.
Okay, let's see. Let's try it again. Okay. How's that? Better?
There you go.
Okay. All right. Yep, as Janine had said, my name is Vicki Peterson, and I've been a family consultant for Family Voices for quite a while. I have two sons. My youngest has a disability of autism spectrum disorder, intellectual disability, and chronic health conditions. So tonight, the first thing I'm going to start off with is a disclaimer statement for everybody. So the information that I talk about tonight in this presentation is for general purposes only. It is not legal advice myself, nor is Family Voices of North Dakota a substitute for any legal counsel. So the content is not intended to substitute for professional advice. Okay. So along the line, if you have questions, if they are retaining to or pertaining to something that only a legal counsel could ask, I'm just going to have to refer back to that. And I'll start, but then I'll stop every few slides to see if there's any questions. Okay, so guardianship. What is guardianship? Guardianship is the legal process when a person can no longer make or communicate safe decisions about themselves. Establishing guardianship does take result in considerable loss of rights for a person. So it is definitely something that people need to think about. The appointment of a guardian is done by a court order after a hearing. The hearing determines whether the individual lacks the ability to make responsible decisions concerning anything like legal affairs, medical treatments, financial affairs, housing, concerns about their safety or health. And the courts will always take a look at the least restrictive for that individual. Typically, guardianships can be partial or full guardianships. Okay, so what is the intent when we think about guardianships or being a guardian for someone you love or a child? The first thing I think about is to protect. So that is to safeguard a person against potential harm, either to their health, their safety, or finances, which is relating back to why you seek guardianship in the first place. And especially when that person does not have the capacity to do that themselves. The second intent is for decision-making, to allow that legally responsible person or the guardian to make decisions and choices for someone, okay? And so again, that is gonna lead you to think about, if you're in a position where you're thinking about guardianship, these four things are really important to take your time to think about, because when you're making decisions and choices for someone else, just like on the first slide, you're kind of taking away a right there. And so there are going to be situations where that needs to be, and then there's probably situations where maybe it doesn't have to be all of it. For their care and well-being, to ensure that the ward gets daily needs met, such as food, shelter, medical care, and quality of life. And for the last intent I think of it is to ensure a loved one's care, okay, to make sure that they're not entering and being in a world where the decisions they make are not for the benefit of themselves. Guardians do have a fiduciary duty, which is meaning they must always act in the ward's best interest. They must respect their values. They must involve them in decisions as much as possible, and also to promote self-sufficiency, again, where it is possible. So the types of guardians, a general guardian is a guardian or can be an agency that has general care and control of a ward's persons, their estate, and responsible for both the well-being and financial interests of the ward. There's limited guardianship, which is a guardian that may be only responsible and makes decisions for the ward in the areas where that ward is not capable, such as some is for financial, like entering financial agreements and stuff. There's also temporary guardian, a guardian where one is appointed as the needs immediate action and only is in 90 days, takes place for 90 days, and then that ends it, or then the process of general or limited guardian takes place. So sometimes there needs to be a temporary guardian in place. Another word they use for this is possibly emergency guardianship, where there might be an incident that happens that one needs to be appointed to make decisions and help with those choices for a vulnerable person. So the difference between them, let me pull these up. So as I said, here's a little bit more explanation about the difference of those. Like I said, that temporary is typically for an emergency situation or immediate time limited period. They can, like I said, be a lot of times those happen during the ones that I've been involved with, or have been in a life-threatening medical decisions. Sometimes, like I said, a vulnerable person may be in a situation where they need to appoint a temporary guardian until a plan is made to decide if there needs to be a full guardian in place or a partial guardian in place for that. Again, that partial guardianship, they wouldn't have as much control of the decision-making and responsibilities. They may only have it in one or two areas. Sometimes you think about that, like, they're pretty good. They don't really need somebody there making every one of their decisions, but maybe their money management skills are lacking. So there might want to be some choices made for financial. And that can be in a partial guardianship, or there are some alternatives to that as well. And then again is the full guardianship, which means that you're basically appointed to make that decision-making, all the responsibilities in those areas for them. But that doesn't mean that they can't be involved in the decision-making as well. So does anybody have any questions to really start out with? If you do, probably just unmute yourself. Okay, we'll just continue. So there's a lot of different words. If you're seeking guardianship or thinking about guardianship, there's a lot of different words and definitions. So I have made a list of some of those. Because it is a legal process, some of those are not terms that we see every day or would think of every day. So one is the respondent. That is the person who replies to the petitioner If you are seeking guardianship over someone, you are the petitioner. The ward is the person to whom the court appoints a guardian. Okay, so that would be the person. So like in my case with my son, when I went through, I have full guardianship over him. I was the petitioner, he's the ward. The petition itself is the document that you file that asks the courts to appoint a guardian. A guardian, again, could be the same as that petitioner, is the person who the court appoints to protect the rights and manage those affairs. So sometimes you may hold two different roles. The guardian ad litem is the attorney or the legal person who represents the best interests of the proposed ward. They visit with the proposed ward, they evaluate the information, they file some reports and recommendations to the court after they've been visiting with them. And the guardian ad litem will make recommendations based on what they feel is in their best interest, okay? So that is either typically some type of an attorney or someone who has gone through the legal process of being a guardian ad litem. Then there is something called a visitor. That is a person appointed by the North Dakota District Court to interview, again, somebody coming into your, and interviewing and talking to the proposed guardian and the proposed ward. The visitor also gives a written report to the court, which can include recommendations on powers to be granted to the proposed guardian. The visitor typically is a person either in nursing, social work, but has no special interest into the guardianship proceedings. Letters of guardianship, those are the documents from the court that states what the guardian's powers are and whether there are any specific limitations to that. Okay, these are the papers that if you are seeking guardianship and granted it, these are the papers that need to be presented to people sometimes in the medical field or the financial field, sometimes even in the school, knowing that you have the power to make those decisions that are outlined in the letters of guardianship. Okay, you might see the word incapacitated person. And under the legal terms, the definition of an incapacitated person means any adult person who is impaired by reason of mental illness, mental deficiency, physical illness or disability, or chemical dependency to the extent that a person lacks capacity to make or communicate responsible decisions concerning that person's matter of residence, education, medical, and other areas. So you will see this word throughout some guardianship if you're seeking it. And so that is actually the legal definition that is used. So other agencies may look at it different, but this is the legal definition for that. Informed consent means a person's agreement to the proposed course of the conduct. In other words, you were presented the information and you're able to make an informed consent. You're not coerced into anything. There's also a physician's report that is made. That report required in some states, in North Dakota, it is required in the relationship to a guardianship proceeding, the need for substitute decision maker. So typically you probably are getting that from if it's your child, you're seeking guardianship over your child's primary care. Physician will write a report really outlining probably what that incapacitated person means to them in the medical field. We talked about other things that it doesn't have to be another person as a guardian. You can have an agency as a guardian, and those are called corporate guardians. And that is a corporation that is named as a guardian for an individual that receives compensation for its role as a guardian under the court approved. And we'll go into that a little bit further. So any questions there? Okay. So ending on that note, here's a little bit about corporate guardianship for those who are incapacitated with no family or friends who can adequately, excuse me, meet their needs. So sometimes, I've worked with families and they're thinking about guardianship, but they don't feel that they are the right people to be the guardian over, or they don't have any family that they would like to be. There is such a thing as corporate guardianships. In North Dakota, 3 examples of that would be Catholic Charities, and Guardian and Protective Services, and there's also Guardian Angels. So they hold some of those same intents, of course, are the same, but I've just kind of listed a few there that would be under corporate guardianships. So if a person is thinking about being a guardian, or you're talking to a family member who is thinking about seeking guardianship over, I think it's always very good, even if you feel like it's what I would call a no-brainer. Yep, I'm going to be guardian. I think it's very good to ask questions to yourself about guardianship. So one of them is, when you're thinking about guardianship, what do you want if you're thinking about your child, what do you want your child's future to look like? Would be something that you kind of want to plan out. Because those are some of the questions that come from a guardian ad litem. They like to get to know you, what they feel your goals are for your child. Another would be, have you spoken to your child about guardianship or the alternatives? So one thing here legally is, if you're seeking guardianship and the person you're seeking that guardianship over, or the ward, doesn't feel like they want to have a guardian, they may just want to talk to you about doing some alternatives to guardianship, which we'll talk about. But they also have their rights, and that's where that guardian ad litem comes into. If they don't feel like they need a guardian, they can present to the court as well their facts and findings on why they feel they don't need a guardianship. And basically that gives them the right to contest it. We'll talk about, like I said, questions to ask. Well, I don't know if I need everything that comes in a guardianship. Maybe I only need this certain thing. So we should think about the alternatives to guardianships, because there are some. There's also a cost typically for guardianship. One of them would be the attorney. I mean, you're dealing with the legal system, so attorney is the way to go. I mean, you could actually do it yourself, but there would still be fees, because there's filing fees for all the paper. And again, it's not recommended under the North Dakota courts. In their website, they don't, that's kind of their wording, they don't recommend it, but there is self-help pages there as well. What are the strengths and weaknesses of my child in managing their life situations? So, just as we think about it when they're young, we need to think about it when they're becoming adults as well. And what if guardianship is sought, but my child doesn't want a guardian? That's what we talked about before, that contesting a guardianship. They do have that right. But these are things just to think about. So in my own situation with my son, he has severe intellectual disabilities. So, I mean, a lot of people would say, of course, you're just going to be the guardian. But I did think about, other things of, if I'm guardian, what do I want his life to be like? Who do I want to be in his life? Do I want a co-guardian here? Am I already thinking about if something happens to me? So there's still lots of questions to ask yourself. Okay, so here's just a little screen that shows you, as I told you, judges always look at the least restrictive for award. So at the very top, you're going to see that guardianship. That's the most restrictive. And as we've been talking, that's the one where you are the decision maker for the ward, or if it happens to be your child. And then it kind of just goes down the line of different alternatives that can happen for instead of a guardianship, all the way down to the last one on supported decision making, which gives a lot of freedom, and is an alternative to guardianship, and is one of the newer ways, or I wouldn't say ways, what do I want to say? Newer avenues that someone could choose as an alternative to guardianship. There's just another slide. Okay, so one of those is that we talk about if you're working with either Social Security or guardianship, this representative payee will come up. So a representative payee is a person or an organization that is appointed to receive the Social Security or the SSI benefits for anyone who cannot manage their direct financial for their benefits. So if you're thinking like corporate guardianship, that corporation may become the representative payee over the ward that they seek that for. Like myself, I have full guardianship over my son, and I am his representative payee for his Social Security benefits. So those words are going to come up. So I just have a little screen here that talks a little bit about that. Anybody have questions on what a representative payee might look like? Again, they're making those financial decisions over a benefit that the ward may be receiving, which is Social Security or SSI benefits. Okay. So another alternative, maybe if you're just thinking to guardianship, that, I'm only really worried about them maybe entering into a financial agreement or understanding the ways, I should say, of money. So maybe you might seek power of attorney instead of guardianship. So I have a couple of slides here that would describe that. So on a power of attorney, they can name the agent to handle the affairs before anything happens, okay? So don't have a great example of that for a young person, but, a lot of times in the elderly's family may seek power of attorney once maybe their parents get older, so they can do that before they become incapacitated, okay? A guardianship only happens afterwards, okay? So if you're seeking over guardianship, they already have to be incapacitated. Power of attorney is a legal form, but not a court form, okay? Guardianship is a legal and a court form. A power of attorney is going to cost typically less money, takes less time to set up. A guardianship is usually more costly, it takes longer. Not all institutions may honor power of attorney, but most do. And it's really becomes legal. Like in North Dakota, you can just actually get it notarized. So, and the North Dakota court system have templates for powers of attorney in North Dakota. And you do want to make sure that if you are seeking power of attorney and you decide to move to another state, that you look up their legal forms for power of attorney, because it is a legal form. It's not a court form, but you want to make sure it matches that state. And so we know too, they would have more choices under a power of attorney, so it would be less restrictive than a guardianship would be. And I do have another slide, but yes, even when you're having guardianship and that ward moves, you do need to change those things according to the new state that the ward is living in or moved to. Okay. So I'm going to touch very little, but on supported decision making, that is also another alternative to guardianship. It is probably the least restrictive alternative to guardianship, but it is a tool where a person with a disability can be empowered and supported in the process of making their own decisions to whatever extent possible. And it is that alternative to guardianship. So in North Dakota, this was like a national advocacy legislation, but in North Dakota on March 19th in 2019, Governor Burgum signed the House Bill 1378, and it did become law in North Dakota, and it was the seventh state to sign such a bill. And this was immensely important for persons with disabilities because it actually gave them the right to make those decisions with just support from either family or friends or advocates that have their best interests at heart. Okay. So it is a written agreement, and it formalizes that supported decision making. So in supported decision making, it is the person with a disability that is making the decisions. The decisions are theirs final, okay? But they may gather some friends or some family, or like I said, some advocates that help them make those decisions. So someone would be able to go to them and say, hey, an example, I want to buy this car, but I'm not really sure about all the paperwork that I need to sign for it, or the money that I need to sign for it, or what the warranties may look like on that. They would have a supported friend, family advocate that could help them understand that. But in the end, it is that person's final decision. It is their decision. Okay. And like I said, that's the newer one. So sometimes that's a little bit harder to explain, but there are some really good trainings and stuff that have been done on it that are out there to really give more information on supported decision making. Okay. As I said, this is going to talk about those roles in supported decision making. Again, this would be an alternative to guardianship. That, as I said, the decision maker makes the final decisions. That would be more likely the person with the disability. Okay, they get to choose people who they want to help make them. And those people that they choose are called supporters. Okay. And they can be anyone, like I said, friends, family members, providers, anyone, as long as they agree to serve in that role. And the supported decision-making agreement is a written plan. Okay, so it is developed by the decision maker. And there are templates out there that can be used for supported decision-making. And because it is law, it is held up in North Dakota as a legal agreement. Okay, so it covers the legalities of having that person make those decisions with those other people as supporters. So the courts do recognize it. Here are some things that you would think about in supported decision making, like learning to manage money. Like I said, that example, of needing some support to learn how to manage my money. Maybe, like I said, signing financial agreements of any kind that get really complicated. A person might want the support in there, or health, making sure that they're getting to medical appointments or understanding procedures in the health. Or sometimes it may be needing that support in housing to explain languages on a lease, or other types of leases, or any of the, understanding language could be a big area where maybe you can make those decisions. You just need somebody to help explain those to you and how it fits into your life. And there's a website there that does have some supported decision-making templates on it. Okay, so how are we doing so far? Any questions that you want to ask now, or if you want to hold them till the end, that's fine too.
You'll have to take yourself off of mute.
Yep.
So you just click on the red microphone button to do that, if you have any questions.
Okay, we'll just continue. That's fine. And so now I'm going to talk about kind of the process that goes through. Of course, these are just kind of headlines of what the process would look like, because it might look different for other people, again, depending on what type of legal situation they are in. But typically it is to go out there, retain an attorney. Good idea probably to call around because, you know, if you have an attorney that you know, that would be great. A lot of attorneys do guardianships, but it's important to retain that attorney. And then collect and process all the information that is on for the petitioner on the proposed ward. Okay. We find out and they name a guardian ad litem, the visitor, and the expert examiner. The expert examiner, again, is that physician that knows your child. Those are notices that go onto the petition. Then that petition is prepared and the appointment of guardian and the confidentiality forms that you need to sign. These are another reasons why you have an attorney. The attorney prepares all these forms for you. They prepare the orders to appoint the guardian ad litem, the visitor, and the examiner. Each of those have to sign forms. I don't know in all cases, but in like our case, the attorney had a list of guardian ad litems that were in the area. You have to file the petition then with the court, and then there's a hearing date. They prepare the notice for the hearing dates. All the rights are in there. They have to serve those rights to those people, including the ward. They file and proof all the affidavits that need to be presented to the court. Like for one of mine was, I'm a single mom, and my son is also the co-guardian. So there were affidavits that we needed to sign for that. And then every person who is seeking to be a guardian needs to complete the guardianship training and present the certificate that goes to the court with all the paper, and affidavits and statements of rights. All those have to go to the court. And that training is completed. There's a website coming up where that guardianship training has to be completed. When you're done completing it, it prints out a certificate for you. If you're having a co-guardian, they also need to complete that training. And then it's really getting that hearing date and having the judge hear why you want to be the guardian. So there is the website for the North Dakota's guardianship training, and no, you're not graded on it, but it gives you a lot of information of what you would need for guardianship in North Dakota. And then there's always little quizzes after that as well to make sure you're understanding what you're reading. So you've gone through your court hearing and you were awarded guardianship. So there's processes afterwards as well. So after guardianship is established, there are forms that need to be filled out. Those are also on the North Dakota court's website. One of them is a beginning inventory. So the questions asked on there are basically assets and you know, what the ward has, where the ward lives, you know, is living with you, those types of things. And then there's also, you have to do an annual report as well. So each year you have to fill out an annual report. And then in North Dakota, every 5 years, there is a review of guardianship. Okay. So every 5 years, you should get a letter from the court, the county court where that guardianship took place, and attend a 5-year review hearing. Now, most that I know still are done by Zoom. They still use that mode for that. Probably the question that comes to me a lot is, do I need an attorney for a 5-year review? I don't know if you do, but I can tell you it's not required. Okay. So when we come to costs, so guardianship does cost. Okay. Again, once because you're hiring an attorney. Those can vary throughout the state, and that's why it's a good idea. If you don't have somebody as an attorney that's going to do, you might want to call a few just to ask what their cost may be. And in North Dakota, we have a couple of establishment programs that can help fund guardianship. There is the one provides financial assistance for the petitioning for that guardianship. It has a limited amount of income that the ward may have, which is at 100% of federal poverty level. So in basic words, the ward cannot have a lot of assets and money for that program. And this one, the consumer or the ward cannot be under DD program management services, okay? So they cannot be having a DD program case management service, okay? On this one, the form that you fill it out, that's one of the questions it will ask you, right? When you get to a point and it says, do you have a DD case management? If the answer is yes, you need to stop here. So there is a newer one. Oops, not sure where it went to. I'm missing a slide. Anyway, I'm just going to go back. So there's also another guardianship established program that is for those who do have DD program management. It is limited state funds, but it is a separate form that you can fill out. Your DD program manager can help you fill that out. That offers some dollars to help, again, with that guardianship training, or I'm sorry, seeking that guardianship.
There it is. Now you can see it.
Can you see it? Okay. Okay. So this is the guardianship funds without developmental disability case managers. So the eligibility for that, again, you cannot have a disability case management under that program. You still must be considered an incapacitated adult, and I have listed the century code for that. And the ward must have income at or below 100% federal poverty level, which is currently at 15,650 listed for that. The application process for this one, again, remember, no DD case management. There is the application form. You submit that to the North Dakota DHHS Aging Services, not the court. And once you look at the form, you need to include as much information as you can about medical evaluations, treatment plans, or documentation that supports guardianship. And again, that's going to lead back to the ward and their title of, to seek that, you have to be an incapacitated adult. And then there are recommendations made to the court, either for the approval, denial, or they might need more information. If the request is approved, the referral source will initiate action and complete the guardianship process. The referral source will be responsible for securing an attorney to complete that petition within that funding gap that they have, okay? Also, the court then will appoint a guardian ad litem and a court visitor, just as they would through a regular guardianship. And all the bills are submitted then to the Adult and Aging Services section at DHHS for payment. So, seeking guardianship fund for those with developmental disabilities who do participate in the disabilities case management program. So they actually must qualify for that, must have a developmental disabilities case management in that program. The incapacitated adult must still be in play for eligibility, as it is in the other one. And again, they must have the income of 100% of federal poverty level or below. This has, like I said, a different application process form. They kind of look the same, which is why I put them in there. And you'll notice in the middle of the application, that's the question asked: do you or do you not have a developmental disabilities case manager? Again, must be coming from a referral source such as a provider, including all the same types of information to prove incapacitated adult and why you would be the best choice for guardian. Again, the court is going to determine that incapacity and appoint the guardian. Again, the recommendations to the court can be approval, denial, or needs more information. This one, if the request is approved, the referral source initiates action to complete that guardianship process. And then that referral source, proposed guardian, and the DD manager will be informed of the amount of funds that are available for that person. Typically, they have been $3,000. And there are questions, are attorneys doing that? Yes. I mean, that program has been used quite a bit. So that was a lot of information. Any questions on those?
I have a question. How often do you have to take that guardianship training? Is it just that once when you're seeking guardianship, or is it every renewal period?
No, it's once, okay, for that initial guardian. But let's say later on you decide that you are no longer can be guardian, or you have, like I said, sharing that guardianship. Everybody needs to take that test one time. Currently, I don't know if it'll stay that way, but currently that is it. And it isn't that way in every state. Not every state has guardianship tests that you have to take.
Vicki,
Anybody?
this is Jolene. I have a question too. Do those
Okay.
funds help pay for the ward's attorney and the parent's attorney, or just one or the other, or everything?
No, if the total amount of the award is funded, that can sometimes go the 3,000. I can't say that it always does, though, because once that money is awarded, then really it goes back into the attorney's hands of what that decision. So let's just say you are seeking that and you were awarded, and let's just say you were awarded $3,000, but you're finding the only attorney that you can use is $5,000. So there's an extra 2,000 there. Is that for the guardian ad litem or someone else? That would be a kind of a legal question to ask for that attorney. But can it be used for that? Yes.
Okay, thank you.
Mm-hmm. Anybody else?
Yeah, can you hear me?
Okay, well, we'll just continue.
We can't, Jen, there was another question, but I can't hear her.
Oh, okay. Maybe they can speak up.
You don't hear me?
I still can't hear you very well.
Okay.
Can you put it in the
Can you
chat,
put it
maybe?
in the, yeah, put it in the chat.
It's hard for me to see the chat, so if you see it, Janine, you can just read it.
I will.
How about anybody else? Okay, well, I'll just continue, and then when that comes up, I'll answer that question.
Okay.
So establishing guardianship in North Dakota for a child who is at least 17 years and 6 months old. This can happen in North Dakota. You can start the adult guardianship process for an unmarried minor who is at least 17.5 years old and have it take effect when they turn 18, using specific court forms and procedures to prove incapacity and best interests. The purpose to establish the guardianship before the ward would turn age 18 and automatically then take effect on the 18th birthday. And you can see there, I have the website for the specific forms for this. So this one may differ a little bit from just seeking guardianship, not at the 17 and a half years. You can always start the guardianship process ahead of time. Just from personal experience, no legal experience of it, but personal experience, it's kind of good to at least think about and start working on it at about 6 months beforehand. Especially like if you don't know attorneys, or you need a little bit more information about the process, or haven't really maybe come up to that final decision, you can certainly start the process. But when you start that process, typically your hearing date is going to be past the age of 18, because if it wasn't, they'd still be a minor. And those are two separate types of guardianship. But North Dakota allows you to do this at 17 and a half years of age. And then right when they turn 18, that's when guardianship takes effect. And so to do that, there are some separate forms that you need to fill out for that. There are separate questions that they ask you for that. Okay. So again, if you find that confusing, is this something you must do? No, you have a right to do it then. Okay. I do get calls and they say, hey, Vicki, I went through guardianship, but our hearing date is 3 days after my son turns 18. It's okay. It's okay.
Before you start the next slide, the question was, they're wondering if being a single parent, is it required to have a co-guardian?
Not any laws that I've ever seen. A co-guardian is a choice.
Thanks.
Okay. We talked about that 5-year review. So the guardianship must be periodically reviewed by the judge or judicial referee to decide if guardian should continue with that current guardianship, continue with different guardians, or end that guardianship. Those are 3 things that can happen in the 5-year review. I won't lie to you, after I sought guardianship and the 5-year review came up, even though I'm very confident I'm a good guardian for my son, it kind of freaked me out a little bit. To think that I'm doing this again, maybe they don't think I'm good enough to be a guardian again. But it was a pretty simple procedure. But again, at this time, I have just been with families when they're doing their 5-year review. And sometimes it can be nerve-wracking, because maybe during this time, the ward has decided they don't really feel like they need a guardian anymore. Even during the 5-year review, the ward still has rights to contest if they would like to. And again, when they're contesting, they have to have their own proof of why they do not need a guardian anymore. Okay. Or I've been on some where they decided they don't want to be, a parent doesn't want to be the guardian anymore, and they want to switch over to corporate guardianships. Okay. So this is what can happen during that 5-year review, but those are the things, the 3 main things that they take a look at in the 5-year review. They can ask you questions. Did I ever feel I needed an attorney at my 5-year review? No. But I've never seen anything that says they can't be there either. Just remember, they're probably going to charge you for that. But a 5-year review, and at least 90 days before ordering appointing a guardian expires, the district court will mail you a notice of the review hearing and the date, the time, and the location. So if you are the guardian, you'll likely receive an information related to continuation of guardianship. That is a form that you must fill out and return to the court as soon as possible. The notice of the review hearing should have the deadlines to return the form.
So once you've gone through the 5-year review, and let's say it is the number one and they're continuing with the current guardians, you will get new letters of guardianship. Okay, they will have new dates on them. When you first achieve or have that guardianship, letters of guardianship in there, you will notice the clause that talks about the 5-year review. Okay. So it does talk about expiration on that date. Okay, so you will get new letters of guardianship afterwards. If they continue with different guardians or it ends, that of course is a whole different process. Again, if you're going to go corporate guardianship, then that takes a whole nother process with the agency that you choose. If it ends, it ends. It becomes no longer a legal document or a court recorded document for you to use. Any questions on a 5-year review?
Just a different question.
Yes.
So far, I'm looking to be a guardian for my son.
Yes.
And so far, they have appointed an attorney for him, but not one for me. So my question is, do I need to have an attorney, or should I just go by myself and let the one that they have appointed for my son to do that?
That's probably a situation that is more legal. So I probably can't answer that the best for you.
Mhm.
I would say if you have questions about that, because I would, somebody legally would have to know why they appointed that guardian ad litem, because there could be different reasons for that. And those would be legal reasons. So I couldn't really answer that. But in general, should the person who is seeking guardianship that wants to be the guardian, it is probably a good idea to have an attorney or at least be able to speak to an attorney. Is it completely required in North Dakota statute? It is not. There is on that North Dakota website, the self portal, but again, you have to file all the same forms as you would if you had an attorney. It's just your attorney is the one that files those forms. But I'm not going to say to you that you need an attorney or not need an attorney. Those are just the options that you would have, because I'm not sure why, or the circumstances of why a guardian ad litem was appointed, like who appointed it? Was it the court?
Yeah, it's the court.
Okay, so to me, that's a singled out situation. The situation may look different since the court has already appointed a guardian ad litem. So I would either speak to the court about that, or if you have already, information from the guardian ad litem, they may be able to tell you as well, because that would be a legal question. But for your safety, I guess I would check into it.
Okay, thank you.
Mm-hmm.
Vicky, this is Melinda with a question as well. So, are you saying the guardian ad litem is the attorney that's appointed by the court? And is that the attorney that you can use the establishment funds to help pay their fee? But then the guardians themselves would want to hire a separate attorney, like for which we would pay ourselves?
No, so the establishment funds is a solid fund. Okay, it is used for the process of guardianship. Part of the process
Okay.
of guardianship is a guardian ad litem. A guardian ad litem is one that is representing the ward. They represent the best interests of the ward. The person who is seeking guardianship, the petitioner, or you, probably as a parent, if you're seeking guardianship, is recommended to have their own attorney. Okay, I don't know anybody who's gone through it without having their own attorney, unless they were an attorney themselves. And even then, you'd have to think about that. Is there conflict, or does the court feel there might be conflict? And I wouldn't be able to answer that for you, again, because it's a legal decision. So when you get those establishment funds, then it's a solid money for the process. Whether it can be used for the guardian ad litem would be what is approved and what are you using for that attorney, okay? Guardian ad litems also can have their own costs, okay? They're not set in stone across the board at what each guardian ad litem gets paid for this, okay?
Okay, so it would be, say that, just for the sake of simplifying my understanding, say that the establishment funds that they weren't in the picture and you didn't qualify for them. You could potentially have a situation where, and in our situation, it would be us as parents and my daughter as ward, where the court would appoint a guardian ad litem for her that we would be responsible for paying for. But then if we wanted an attorney to represent us as the petitioner, then we would also pay that attorney. So we would potentially pay for both of them.
Correct.
Okay.
Okay. So it also depends on who you pick as an attorney. Because again, a legal question, I can't answer how all attorneys work. I can give you an example, which is lived experience for me. So when I was seeking guardianship, this is without no establishment funds. Okay, we wouldn't have qualified for those. And at the time I was seeking it, the DD case management one wasn't actually in effect. Okay, so when I went to visit with my attorney and we talked about everything that needs to go through there, he laid out to me, okay, this is what this is going to cost, this, and this, because there was a cost to everything, right?
Yeah.
And then he said, so here is a list of guardian ad litems that we have here in this area, that are filed with the court. And basically he said, do you know anybody That's what he actually asked me. And I actually knew someone. So that is the one who I had as guardian ad litem. I was also told by my attorney that the guardian ad litem is a separate cost from his. And so I paid him directly as a guardian ad litem, and the rest I paid through my attorney. But I can't tell you if that is the way with every attorney, because I don't know that for a fact, because that's a legal question. But no matter what, the ward has a guardian ad litem. They must have somebody who represents them.
Right. Yep. Yeah.
So,
but that would be someone that, upon visiting with the attorney that you're finding as the guardian, that they may be able to direct you to the guardian ad litem, and the person that you're choosing would then be appointed by the court on behalf of,
right.
in this case, the
when
child.
we're talking about appointment, that means they're already filed with the courts. Okay. So they are allowed to represent a ward. Okay.
Okay.
And the court recognizes that. If there was no one to be found, or I guess if your attorney didn't know of anyone, it would go through the court to find someone, because that is an extremely important part of the guardianship process, because they're representing the ward. And can they be the same as the attorney you choose to help you through the process and petitioning for guardianship? No, because it would be a conflict of interest. Does that make sense to you?
Yeah,
Kind of.
yeah, I think so. I'm just like, so if we were behind the 8 ball and I guess did nothing, and then discovered after she turned 18 that we needed to seek guardianship,
You can.
the first step, I guess, maybe this is my question. The first step is to find an attorney for us, the parents, and
Correct.
they can probably help then find the guardian ad litem attorney for my daughter.
Correct. So I know
Okay.
attorneys that have that process. The thing is, if there is an attorney, and again, a legal question I cannot answer, I can just, state what a court would do, which a court then would have to find a guardian ad litem because it is part of the process.
Okay, but even if the court appointed it, then their fee would still be paid by us.
Yep.
Okay. No, I think that I understand what you're saying there. Thank you.
Yeah. I mean, there's some other things to think about. I mean, it's not in this training, but I'm sure I'll do a training pretty soon again on ABLE accounts. I mean, if you have a child that already has an ABLE account, people have called me and I've confirmed this with the IRS because that is the leading agency over an ABLE account. You can use the ABLE accounts to pay for guardianship, but maybe you don't pay for the whole guardianship out of there, but they could pay for their own guardian ad litem. Okay, because that's representing them. Okay.
Right. Okay.
So that's something to think about. Is it necessary? No, but yes, the ward could be responsible for paying for their own guardian ad litem, but you would also have to work that out with the ward or your child, because in an ABLE account, it is their account, but it can be used for that.
Okay. Yep. Okay.
So some of that's complicated and legal, and I'm in no position to answer those, but those are some general terms. So yes, if they were past 18 and you were seeking out, the first step I would recommend that you take is to find your own attorney.
Okay. That makes sense. Thank you.
Yep. Any other questions?
Jeremiah for Augustine.
Yep.
Can I, because I let my wife do this, can I join later by being or it just automatically comes in with the since of being the father? Or I'm gonna have to do a co-guardianship later. Then the second question is, how are we gonna be filing taxes this year since he's turning 18? These are oldest son and past experience.
Okay, I'm not really sure about that question.
Yes.
Maybe I didn't understand it correctly, but it sounded more legal to me.
Mm-hmm.
Yeah, I cannot answer legal questions because I am not an attorney.
Okay, which part is it legal?
I think he asked if
I might
he
have
can join in as a
misunderstood.
I think he asked if he can join in as a co-guardian later. Like if the wife establishes guardianship first, can he join as a co-guardian later? And the answer to that is that's yes.
Okay.
The answer is
The
yes.
answer is yes, you can. Mm-hmm.
Okay. And then
There
about
is
filing.
there is a court cost though for filing that. And you must take the guardianship test.
Okay. Since I didn't have time, so I didn't want to delay anything else. That's why I let her go fast and everything. Yeah.
Sometimes it's easier if you know you're going to be a co-guardian to do it right away.
Yes.
Because then you're only filing those papers once. But if you do it later, there are those papers that need to be filed. And then you also have to file the certificate that you took the test as well. Okay.
And the test you're talking about, is it online test or gonna have to be going to online test?
Yes.
So,
and when you get this PowerPoint, it'll be that it'll be in that PowerPoint, that website that you go to take that test.
okay, and you can do it. And do you have a timeline to do it on when?
You do not. You just have to have it completed before the hearing.
Oh, okay, before the year. Okay, that is not something that
because if you did it with your wife here, or at that time, you would both complete that test at the same time. It would go to an attorney or you would present it to the court. If you are waiting, she would have to do it. But then if you want to come on as co-guardian, you would complete that before you present to the court.
Okay. So I can do it. So that means in the appointment day before the hearing, we're gonna have to go together at the same time if I decide to do the test now.
Okay, yes. I believe the answer to that is yes.
Okay. Sounds good. Thank you.
Mm-hmm. Thanks, Jolene. I'm sorry, I didn't quite hear that. So.
Yeah, no, I thought he had a second question too, but I'm not sure I caught that one.
So the
I'm not
second question
sure
was
either, but he could put it in the chat as well.
so it was about taxes. 18 years old. Like, is this gonna be filing like, or we can file him under the as parents still?
So that is something I cannot answer. No, I don't work with taxes.
Oh, okay.
Okay.
Okay. Sounds good. Thank you.
Mm-hmm. So if you're a guardian and you're transferring to another state, that's a transfer of jurisdiction. And I have in their guardianship or conservatorship because it also would pertain to transferring to another state. It's a 3-step process that you must complete. The first process is you petition the North Dakota State Court ordering that transfer of guardianship to another state court. Okay, that is a form. There is the website where you can find that form. Then you must work with the other state court to get an order accepting that transfer of guardianship or conservatorship from North Dakota. You work directly with that other state to fulfill other states' court's process and obtaining the order accepting transfer. So each state can have a different process for guardianship. Okay, so it's very important if you're moving to another state that you go to their state court website and look up on their guardianship what their provisions are for accepting guardianship and obtaining guardianship and keeping guardianship in that state, because it probably is not the same as North Dakota. One of the things, like I talked about earlier, is some other states you would not find a 5-year review, okay? But you might find something else, a different form that you have to fill out every year, okay? The third part is after the other state court issues the order accepting that transfer, you must make a motion for a final order confirming transfer to another state. Okay, and then there is a website down below, again, on the North Dakota website that will help you look at transfers. And this is something you must do, okay? So if you read in the statute, if you actually go to another state and you don't follow the process, that guardianship is not considered a legal or court order. So just make sure that if you're moving to another state, you get those things done, okay? An example of one that I helped with, just a family recently, just get to the website of at least another state because they couldn't find it, was the fact that they were changing the ward was changing guardianships and moving to a different state. Okay, so this process still all needed to be done. Some other things to think about is there always has to be a final report if the ward passes away. So there is also forms to fill in those. Or if you're selling any of the ward's personal property, any of the real property, such as land they may have, if you're selling that, there's forms for that. Again, appointing a successor guardian, say you don't want to be anymore, there's a form that would either go to corporate guardianship or naming another person as a guardian. That is also a form. And then there is a form that can be used by the ward to request termination of guardianship. So it's a good idea to go to that North Dakota website, that courts, and just look through all the forms. They have all the forms and all the directions in there. You know, if you're thinking about guardianship, I would recommend looking at all of them. And then if you have guardianship, I would still recommend every once in a while peeking at all those. Okay. This last passed legislation, a bill was passed to create a North Dakota Office of Guardianship and Conservatorship. This office was created by Senate Bill 2029 during the 2025 session. It has a phased implementation, so it's not fully into effect yet, but they hope to be fully operational by April 1st of this year, 2026. This office is going to provide comprehensive oversight and regulation of guardianship and conservatory services. The office will be a multi-part structure, including an operations committee, a review board, and an executive director. The primary goals listed in this legislation were to monitor guardianship services, develop ethical standards, and protecting those with vulnerable individuals. Key provisions that they are doing is creating a registry for guardians and conservatories removed for good cause. Okay. Establishing licensing requirements. Those would be for corporate guardianships. Development of complaint and disciplinary procedures. This is just an overview. This is not the whole the bill or every portion or part of this guardianship and conservatory office. But the website is down there for the Century Code that you can take a look at this. But the office will have the power to investigate complaints, again, issue licensing, provide training, recommend rules for guardians and conservatories, and also set limits on who can serve as a guardian or conservatory. So there's not a whole lot more I can say about this or answer questions on this because it isn't fully into effect yet. But again, you can read the Century Code on the bill and how it was passed and how it may affect you as either being a guardian or if you're seeking corporate guardianship or you're actually working for an office or an agency that does corporate guardianship. So we don't know the full extent of what this was or will be yet completely. And so I just wanted to mention this because it's new legislation. This was not there before. Before it was the courts who really had the say over guardianship. They still play an important role, but now we have an office. So some tips. Know your role as a guardian. I think is very important. Again, shop around for attorneys unless you know one because prices can vary. Think about, again, whether you want to appoint a co-guardian. It's a little less work if you do it at the same time, but you certainly don't have to. And then keep good records of financial and the health of the ward, because that's why I said take a look at all those forms that you have to fill out so you know the questions so that you're keeping very good records, because those will have to be presented every year at the annual report that must be done. Okay. And I think that's it. Yep. Sorry, I went a little over time, but I'm more than happy if you want to stay on a little bit and ask questions. I think the PowerPoint will be sent out to you later.
Yeah, I was just gonna say tomorrow, hopefully, depends how busy I get, but I will, what we usually do with these is we download these and put them on our YouTube channel on YouTube, and then we load them up on our website. But what I'll do is I will send the recording to you, the one that we place on YouTube with the slides. And so that you have all that information for you in case you want to go back and listen again or share it with a friend, whatever the case may be, so that you have the materials for you. But I'm sure Vicki is happy to answer any questions for you as well.
Yes.
So I'm going to shut the recording off in case there are any other questions at all. So I'm going to shut the recording off, but we'll still be here.